Uh, yeah, I think this is a go. Sure. Good afternoon, everybody. All the panelists have joined us. We are ready to start. My name is Abhijit Sadikle. I'm a senior associate with the dispute resolution team at Shardul Amarchand Mangaldas. Today, I have the pleasure of introducing our vastly experienced and diverse panel that will be discussing a very interesting topic. The topic for today is very nicely titled Confronting the Expected, Embracing the Unexpected, Resolving Disputes with PSUs. Today's discussion is sponsored by Trilegal. The panel's positions and experience set us up for an engaging discussion over the next hour on the topic that is very relevant to Indian arbitration space. Just as a matter of disclaimer, the views expressed by the panelists are personal and not of the organizations they represent. To start with the introduction, I will start with Mr. Mishra. Mr. Ajay Kumar Mishra is President, Contract and Claims Management, Dilip Buildcon. He has over 33 years of experience in finance, administration, and infrastructure matters. Moving on, Mr. Kunal Mehta is Head Legal at JSW Energy. He has wide experience and has worked with leading law firms including Herbert Smith, Freehills, GSA, Shardul Amarchand Mangaldas, and Khaitan before joining JSW Energy. Miss Tine Abraham, she's a partner at Trilegal in their Delhi office. She specializes in commercial disputes. She regularly represents Indians and multinational clients in institutional and ad hoc arbitrations and before various courts and tribunals in India. Her expertise include infrastructure contracts, foreign investments, regulatory issues, shareholder disputes, and insolvency proceedings. Moving on, Mr. Venkata Ramana Korrapati. He is Vice President, Contract and Legal Tata Projects. He has over 3 decades of rich and diverse experience in legal matters involving environment laws, construction contracts, trademarks, corporate laws, industrial laws, company law, and of course, arbitration. And finally, Mr. Vishrov Mukerjee. He will also be moderating this session. He's a partner at Trilegal in their Delhi office. He's also a part of the firm's dispute resolution practice and has diversified experience in regulatory disputes, infrastructure sector arbitration, and commercial litigation. With this, I hand over the baton to Mr. Vishrov Mukerjee to moderate the session. Thank you.
Thank you, Abhijit, for that wonderful introduction. And good afternoon to everyone. Thanks to everyone who's joined, and a special thank you to all our panelists for taking time out and attending this and agreeing to speak at this panel. We have a very interesting discussion lined up today on resolving disputes with public sector undertakings. We are all aware of the fact that the government is the biggest litigant in the country. We have a diverse cross-section on this panel from someone who's on the business side. We have two in-house counsel, and we of course have Tine who's going to give us the external counsel perspective on some of these disputes. We will be in the course of this panel discussing various issues and challenges that arise at various stages. We'll be addressing the pre-dispute stage, the dispute execution stages, and also some of the strategic inputs and factors that need to be considered when you're litigating against the government or against government companies. And just to start off the proceedings, I would just call upon each panelist to maybe spend a couple of minutes just giving us their introductory thoughts around the kind of disputes that they are seeing and some of the issues that they feel are important for the purposes of this panel. So we'll just start with Mr. Ramana. So if you could start, and then we'll just go around to the other panelists. Thank you.
Good afternoon, everyone. It's a privilege to be here, part of this session. I think to begin with, any arbitration proceedings, whether it is public sector or private sector, the parties are already in a contentious position. So that's where, the issues come, and even a lot of technical issues are raised at various stages. And coming to the disputes in the infra space itself, the most important and the biggest disputes pertains to prolongation costs. And in prolongation costs, the contentious issue is who is responsible for the delay. I think that is something which is more a fact-based one. And the second biggest disputes that would typically come up are the variation claims. Variation claims are more technical in nature. But I would say the largest component of disputes in infrastructure cases would be the prolongation cost disputes.
Vishrov, you're on mute. So
sorry. It's a litigator's habit. Mr. Mishra, if we could hear from you on some preliminary thoughts on this topic for today.
Thank you, everyone, for calling me for this session. As my experience and whatever we are doing in, and basically we are working with NHAI, which is one of the largest PSU in terms of expenditure in the road projects. What I feel is that the from misrepresentation. The clause which is least read is the representation and any tender or any agreement. So misrepresentation, authority says, or the PSU says that I am having all the things under my command which enable this agreement. It means they should have everything in place. For example, forest clear, for example, ROW, then that too encumbrance free and vacant access. Between encumbrance free and vacant access, they take, for example, I'm only quoting it as an example. So vacant access means where you can make the road or construct the, and it happens, ROW happens with the this transmission line also, GAIL also, NHI in particular. So when they make a misrepresentation, and they misrepresent in two places. Once when they go for the project approval committee to the government, they said that we have 80% of land with them. But when they go at the site and after signing the agreement, they said that no, we don't have that land. We have that land, but not the full ROW. From there, usually the variation clause starts, and it is the cause of the delay. So, and second, what I can understand from these agreements is disclaimers. So these disclaimers are put there. For example, the clause in the NHI agreement that rule of contra profundum will not apply. I think that this is not legally tenable also. But what they feel that this is going against us, they will put in the agreement itself, rule of contra profundum apply. Whereas that is not a case that you cannot go to the court. So they could have written this also. These are certain variations, and I feel that the main problem comes from the representation and warranties.
Thank you for that, Kunal.
Sure.
I mean, your experience, and it would be wonderful to also hear, given that you also have vast experience on the regulatory side of disputes, which, while not strictly arbitration, is is an alternate dispute resolution mechanism. That is, so if we can just have your thoughts on some of these issues.
Sure. First of all, thank you to Trilegal and MCIA for inviting me to this panel. So I would like to sort of start with a generic background that litigation is generally believed to be an unproductive investment, both in terms of time and money. And the ultimate aim should be to not litigate as the first step. But in India, what is happening is generally litigation has become the first step instead of as the last resort. And which is why the government has a very dubious distinction of being the biggest litigator. I think one of the main reasons for having a lot of disputes with the PSUs is that there is a lack of what you can term as litigative diligence. As in, before a litigation has to be initiated, from a public sector undertaking, I feel there are not enough diligences done, whether it is a good matter to be litigated or to be arbitrated. It is sort of it becomes sort of an indifference to a claim that a private party makes, which is why a PSU will just go in for litigation without thinking that whether the dispute can be settled, whether they have a good claim or not. So that sort of litigative diligence is sort of missing, which should be there in the first place. Also, not a lot of efforts are made or attempts are made to settle disputes at the beginning. They are sort of just litigation is taken as the first step instead of as the last resort. So there is no sort of accountability in that sense, which is why I think, which is sort of in a broader sense, is the reason for most litigations with PSUs, and that is sort of, I think, is the confronting the expected, because this is sort of has become the norm now, and which is why we are facing so many disputes. Coming to sort of regulatory side also, sort of it is similar issues. You see discoms, or you see state governments, any public sector bodies. Most of the disputes that come are either payment related, or as Mr. Venkata was saying, that they are related with delay or variation in the contracts. So yes, those are sort of wherever a higher amount is involved, it always sort of goes to dispute, because nobody wants to take a call that, oh, this amount can be settled or this amount can be paid to a private party. So if the amount is high, it is sort of it is likely to go into dispute. And then for construction contracts, definitely delay and variation are the two main factors which I also feel lead to litigations.
Thank you for that, Kunal. And Tine, just your thoughts on this.
I think I will sort of summarize what three of my friends here have said and sort of add to the context for our discussion going forward. I think one common point which we need to keep in mind is when you're looking at this whole issue about a commercial dispute involving the state entities or public sector enterprises, it usually arises in the context, in 2-3 specific contexts. I mean, it arises in the context of long-term concession, whether it is roads, ports, airports, whatever it is. So that's one large bucket where we see litigation. The other large bucket, as Ramana mentioned, is in the context of EPC contracts, and it can be in an extremely complex oil and gas project, varying to construction of a 2-room school in a village. So you have the whole spectrum of disputes that can come up in the construction aspect as well when you're looking at government contracts. Now, there again, I think some of the points that came up, and to set also add to the context of our discussion. I think there are a few aspects, right? One is the whole aspect of contract management and how that sort of feeds into a potential litigation. Very often there are discussions which happen. There is suggestions being made, please do this, don't do this. Some of it is often not recorded in a contemporaneous manner. And then when we are at a potential dispute stage, or rather these issues lead to a dispute scenario. So I think one of the preliminary aspects is that whole contract management and how much importance we as parties entering into contracts, whether it is with government or otherwise, into this whole contract management. And the second thing is what Kunal mentioned. How do we then make sure that litigation or arbitration is not what is your first port of call, which is that you try and negotiate the differences which arise. And I think that's equally important as contract management. And the third one is identifying the aspects which are recurring issues of dispute. And I think that's one of the points which Mr. Ramana also mentioned, which is that by now we all know what are the areas in which there is consistent amount of disputes arising. How we address it, be it at a policy level, be it at the level of individual contracts. And this can be dealt with right from the stage of bidding till the stage of an arbitration or in a court. So the manner in which these issues are addressed, and there again, there are several commonalities given that these are recurring issues. I think all of this sort of add into how we deal with contracts when we, in the context of the public sector enterprises. And that sort of sets the background for confronting the known or the unknown. It's both at the same time. So I think those would be my initial thoughts, and I will look forward to a more engaging discussion with all.
I just want to add one aspect of what Mr. Kunal has mentioned. Mr. Kunal has mentioned with regard to the due diligence that has to happen before any dispute is taken to the to the arbitration or for the appeals. In fact, there is a Niti Aayog office memorandum, that is November 2019 office memorandum, which clearly states that the PSUs, whenever they are filing in any applications to set aside the award, they have to go to the law officers, seek opinions from the Attorney General, the Solicitor General, and then file an appeal. I really don't know whether that happens or it's only automatically these appeals are filed.
Thank you. Thank you for that. Now, before we go into the various stages of a dispute and the issues that are surrounding that, given the sensitivity that is involved around litigating with public sector undertakings, especially large corporations, Mr. Mishra mentioned NHAI, we have NTPC, which are literally or are virtual monopolies in their particular sector. A key issue is whether to raise a dispute, and if so, when to raise a dispute. And I'd like to just spend about 5-10 minutes discussing with this panel on what are the considerations that come into deciding when to sort of pull the trigger. And I'd like to start with you, Mr. Mishra, on what are the factors that you would ordinarily consider when you decide whether we should go for a dispute or we should just take the hit and just sit tight.
Vishrov, you also know that this is the toughest question in management, because they are really virtual monopolies, and whatever acumen, the equipment we have, whatever the knowledge we have, whatever the know-how we have only of the road infrastructure sectors. They also know where they can go. For example, we are having 60 ongoing at a time in one organization. Perfect. So in that case, deciding that when to go, when to not to go, because the same office, see, after some time, this whole dispute resolution process becomes a farce. When the people in the government, they start thinking that this is something personal. Okay, I have told you to, we are not withdrawing it. So this type of things, they crop up. Being a human being, also have such type of things. So it all depends on your stake. If, for example, there is one company who is not going to NHI, they can take whatever steps they like. But when you are working in an organization, you also know that you will also commit some mistake at point of time. It may happen because accident can happen anytime. So how to see that mistake? If they are averse to you, this is the quantum of the problem, then they will escalate it and put you under some plan, bring you down. And whereas in other cases, they may not. So it is a very fine line of this thing, when to start it. But usually what happens, we lodge our claim. This is our claim. You want to strike it in the bill, no problem. But we at the proper time, whenever whatever timeline is prescribed in the agreement, that within 30 days you will have to tell to the submit the bill or along with the bill. Usually after the provisional completion or the completion or whatever financial there, if they come out by the God's grace, then we submit a claim. And usually the process of CCI in some alternate dispute resolution. For example, in NHI and most projects, there are, Mr. Venkata must be knowing it, because that is again, I will in the later to that point also. So then whatever amicably is settled, we settle it. Our company's policy. We don't go for much litigation because it may at one point of time or another.
Thank you. Thank you for that. Mr. Ramana, just coming to you, I mean, your perspective on because in that sense, you are, you're guiding the business on from the legal side. What would you look at as as the key factor on whether and when to pull the trigger?
I think Mr. Ajay has rightly put it. There is always a claim that is lodged in a timely manner as and when it has to be done. Okay, and then moving on to the arbitration, it's both a business call as well as a legal call that we need to take. From a legal perspective, I don't want, if the contract is yet to be there's a is this still one more year for the contract to go on, for the project to go on? I don't want to file multiple prolongation cost claims. That is one aspect that I would like to keep in mind. And the second thing, from a business perspective, as Mr. Ajay has rightly put, there may be a situation where you are expecting a completion certificate for one of the projects. Okay, it's the employer may take a hard stand. If I initiate this arbitration now, there may be some issues or there may be delays in getting the completion certificate, or certain certificates that I'm required to get to show that the project has been substantially completed. These will be the business calls that are to be taken. From a purely legal perspective, I would always want, as far as possible, the notice that is given should adhere to the timelines. Though we all know the Limitation Act and that governs in our country, and how the strict timelines that are contemplated in the contract may not be that relevant in our jurisdiction. But it's always good to have a contemporaneous claim lodged and be there. So that would actually protect you, and you can move the arbitration with the appropriate.
Thank you for that. And just to take a slight detour on this, Kunal, given that there are a lot of regulatory disputes, and those disputes as of now are more or less restricted to regulatory commissions. Just like to hear, from a strategic perspective, your views on how arbitration can be a measure to resolve these disputes, and do you think it's a good idea to bring them in?
Yeah. So as you rightly pointed out, most of the power sector disputes are sort of taken to commissions, state commissions or central commissions, and arbitration is not used as much. Although section, I think 79 and 86 of the Electricity Act allows that the state commissions can refer a dispute to arbitration. In fact, in PPAs also, you will see that there are clauses that if it's a tariff related dispute, it will go to the commissions. But if it is a non-tariff related dispute, it will go to arbitration. But more often than not, we have seen that matters relating to sort of dispute between a producer, electricity producer, and a discom are going to the state commissions. In fact, there were a few instances, I think in Gujarat, where the commission had sent matters to arbitration because they said that it is not exactly relating to tariff, so it can be sort of decided by an arbitrator. But that there are very few precedents like that, not too much. In fact, the electricity amendment bill that has recently come, that has removed that reference to where state commissions can send the matter to an arbitration. That sort of that subclause has been slightly modified to remove that reference. So the government's intention seems to be in the direction that, at least in power sector, that the disputes should go to the state commissions or the central commissions, and they are sort of going away from the arbitration. So in that perspective, I think this bill may be passed in the winter session, but the way the government is thinking, it seems that for this particular purpose, at least for this particular sector, arbitration is not supposed to be the preferred method. So that is one.
Thank you for that, Kunal. And just continuing with the theme of the discussion that was there, and there's an important point that Tine mentioned on contract administration. And Tine, I'd like you to probably to set the context of the discussion, and then we'll hear from the other panelists. contract administration and recording what is right and what is wrong, what is being given, whether vacant access is being given or not. It is expected. It's almost as if the unexpected is expected as far as these issues are concerned. How can we change the expected? What can be done to change from a company's perspective? What measures can be taken to improve contract management and this documentation so that it helps people like you and me when we have to actually go into the dispute? We just would love to hear your views on that.
Yeah, I think I was coming more from our experience where very often what you are faced with is that, that there is a great case, there is extra cost incurred or there is extension of time, but you unfortunately don't have enough documentation to support that. I think few things which I would think is central and critical to dealing with this issue is if there are meetings which happen, even if there isn't a minutes of meeting which is agreed between the parties. First and the foremost thing is that if we can, after that meeting, follow it up with a short email by somebody summarizing the 5 key points which was discussed. I think that can go a long way if the parties were to ever reach the stage of litigation. I know that, there are some instances where parties find it difficult to put on a letter that, we need the extension of time because some invoices may not get cleared on time if you put it on email. So I think it is contextual, but to the extent possible, get all of these communications, which is verbal in nature, recorded in emails. The third is, I think, progress of the work. If we are able to regularly record what is the stage of progress, what is delaying it, if it is that there was unseasonal rains for a few days, get that recorded in the manuals and records which is maintained on site. All of these things go a long way in terms of helping you at a potential dispute stage. Similar is, when you're dealing with a bid situation, obviously there is limited flexibility which is available to a party to change the terms of the contract. Be that as it may be the case, if there is any alteration or variation which is coming by virtue of conduct, create a record of that again. It is most often the case that variations and alterations, modifications needs to be in writing. But even if there is no extension, variation, modification in writing to a contract, at least the unilateral communication goes a long way in demonstrating that this was the intent of the parties, and that helps significantly during the course of the contract. The other thing is, aspects like bank guarantee, making sure that sufficient guarantees are maintained. We don't provide guarantee for a longer period. All of this goes again a further long way in limiting the extent of exposure and disputes. So I think these are the few thumb rules that parties can always keep in mind. I know that from our experience, we all realize that it's not always easy to follow through all of it, but maybe keeping some of it in mind for over the course of time is something helpful in the long run, is what I would say.
Thank you for that. Just moving on from this, of course, we're all aware of the expected challenges that we face in either getting things recorded in the MPR or in the independent engineer's report, for that matter. And it all ties in very well with some of the things that both Mr. Ramana and Mr. Mishra have said on this entire issue of representations, warranties, and the information asymmetry that is there in the contractual framework. Unfortunately, that is not something that we have learned to address, despite several decades of contractual experience that is there in the country. But moving on from strategic considerations to the pre-dispute process itself, and I understand that that the moment you go into this, everything becomes very legalistic. Of course, there is a cost to all of this. Delays ultimately have to be compensated by somebody. But coming to you, Mr. Ramana, first, what has been your experience at that pre-dispute stage? Is there an attempt to pull out every trick in the book and delay it? And what are the typical tools of trade, if I may call it that, in order to prolong the process?
See, of course, the mediation bill, and I'm not so sure about how the mediation is going to pan out right now. But the experience so far, whatever is the pre-arbitration methodologies that is contemplated in the contracts, whether it is the dispute adjudication board or the conciliation proceedings that have to take place, they are done very mechanically for two reasons. I think these are done mechanically by both the parties. One is these are not enforceable. The moment these decisions are not enforceable, it's very difficult for a public sector to honor these DAB decisions or a pre-arbitration decisions. So from that perspective, the experience so far has been that these are not so fruitful exercises. And in fact, to take a strategic call, we ensure that the time limit that is contemplated in any of these mechanisms, typically for the DAB, there will be about 50 days or 60 days time that they have to decide. And if it's not decided, we can go ahead with the next stage of the dispute resolution mechanism. So that's a call we take. Having said that, very recently, one of the public sector undertakings have come up with a notification where they are treating the DAB awards similar to the arbitral awards, and they're paying 75% of the DAB award against bank guarantee, subject to it's going to the next stage for arbitration. I think that's a very welcome move because that gives credibility to the pre-arbitration mechanism, and the parties, the contractor would be really keen because he can see the color of money. You know, at the end of the day, he can realize 75%. So that's where we are.
And Mr. Mishra, just coming to you, what has been your experience? If you can just take a minute on that in this pre-arbitration process. Is mediation and conciliation, or even a multi-tier dispute resolution, Mr. Ramana mentioned, which has a DRB or a technical expert. Do you think it's working, or are there any suggestions to improve that?
Totally agree with Mr. Venkata, because see, you will have to understand that from arised. The dispute arise once you are not satisfied, or you go to the independent engineer or the authority engineer or whosoever is the consultant there, and he denies, either he denies or he recommends it. Then he goes to the authority, the matter goes to the approval is taken from the chairman level, depending upon the gravity of the subject. So start the dispute resolution, you are again putting the same thing in front of the same person. Person cannot take two types of decision in his own file, because he will have to say that whatever was right. So this process only consumes time and satisfies cause of the court that you have exhausted all the methods available or the is available to you in the contract. So these are only for purpose that you, and for example, in NHI project, they say that the mediation will be done in the first case. How he can do it? Because our fight is with the. So this is it. Usually it goes futile. Another thing that I want to emphasize here, that has created some conciliation committee of independent experts. See, those officers who are there in that CCI, officers who were earlier in the NHI, and how can resolve the same dispute in which they have themselves written that this is not possible. are certain cases. So this process, because the person who is the things or who is in the dispute resolution process, it should be someone who is independent, independent of anything to do with the things. And in the dispute resolution process mentioned in the contract, it starts from the same biasness, same independent engineer. And usually for example, one thing I would like to add here, I think Tine Abraham about that, if we know that these are certain types of problems, we should address it. BOT road concept, it started in 1997 somewhere, and it is 25 years. And still at that time also ROW was the problem, and today ROW is the problem. We could not address a single thing. All the disputes, they start from the ROW. 97 also see, you take anything, if the utilities has to be shifted somewhere, you need to have the ROW. If you want to construct, if you want to construct the side roads, ROW. So the basic question is that if these are the problems, if we address it now, the road can be constructed in a very less time. Because today all the construction work is so mechanized, unless there is some litigation which stops us. Construction can be done overnight. 1 year more than sufficient, but the contractor or concessionaire should be given free space of like access, and everybody can do it. It is not that they can do it, which can complete the project, and these costs are not inbuilt in the tender. What is some? Therefore, the litigation is there, and they take it personal, because what they say is that we have, you just complete it, then we will give you the balance land. Your machines are not idle, but the planning lies idle. This is the main problem that was being discussed now. If we know the problem of some projects, we should address them first. That is not addressed till date also. I have given you one example. That's it.
Thank you for that. And just to take up the next issue, the whole issue surrounding appointment of arbitrators, neutrality of arbitrators, is something that has been up in the air for a while now. There is some clarity on it, but there still continue to be a lot of challenges. Even from a regulatory litigation perspective, you end up having ex employees of a particular government company sit and adjudicate on disputes that are pertaining to that particular government company or entity. So again, I think we should have changed it to embracing the expected, because these are all things that we all are aware of. But Mr. Ramana, what is there are things that are obviously wrong with the system. Your thoughts on what can be done to make this better, and whether it will help in making dispute resolution more efficient in this framework.
See, I think right from the inception, the problem starts when we issue a notice and there's no appointment of arbitrator that happens. It doesn't happen within 30 days. And obviously, we are left with no choice but to file an application under 11.6. We file an application for appointment of an arbitrator. It usually comes up before the High Court. And the law is very clear. The 30 days time limit is not very strict. And if I have not filed any application, before filing the 11.6 application, if the party appoints their arbitrator, that appointment is valid. But there are many cases, and I'm sure most of the partners, Tine, Abraham, and others would be aware of, where I go to the court and the defaulting party comes before the court and appoints an arbitrator. And the court also readily agrees. The right that has gone away is again being, the defaulting party is empowered to see that this happens. And the court really agrees and nominates the same arbitrator that the defaulting party has pointed it out. So the most important thing I would like to say is, unless and until the court strictly enforce this, the discipline will not come in. That's one thing. Second thing is, I have seen an incident where at one of the courts, this is just before the Supreme Court has called for all the records of 11 applications pending from all the high courts. Imagine for 12 months, my application was pending. It was not coming up. There's a huge pressure from the management on me. We are the in-house lawyers. External lawyers call us and tell it's getting listed. But the management asked me, you can't even get an arbitral tribunal in place within a reasonable time. So this is where the problem is. I think the court should strictly enforce this 30 days time period so that, the moment the application is filed, we should not hear the defaulting party. That's where I end this, as far as application is concerned.
Thank you for that. Kunal, just in your thoughts on challenges with neutrality of arbitrators or anyone who's sitting in an adjudicatory function, what can be done differently?
Yeah, so I think at least some part of it, the Supreme Court has helped regarding the cases of eligibility of current employees of PSUs becoming the arbitrator. So at least that position has been answered. But still, I think some former employees or sort of ex-consultant of the PSUs are still becoming sort of the arbitrator in a dispute between a public and a private company. Although Supreme Court, I think, has in some sense said that if you have a list of people from whom you can select arbitrator, that list should be a broad-based list. It should not only be all the ex-employees of the PSUs. It has to be sort of a wider list, maybe ex-employees of some other PSUs which are not in your sector. So those are some sort of guidance which Supreme Court has given, which I think should, at least that is a step in the right direction. That it is not that the same person is the judge, jury, and executioner in this case, but there are sort of a wider, broad-based group from whom arbitrators can be selected. The other thing is, or you have sort of 3 arbitrators and then you hope that it is not a sole arbitrator thing.
Thank you for that, Kunal. Tine, just coming to you, since we have been told that the outhouse lawyers are not getting Section 11 decided expeditiously. Your tips to get the arbitration started ASAP, if you can just take a minute and what needs to be done by clients or by litigants in order to make sure that they don't face the kind of obstacles that Mr. Ramana was referring to.
I think fundamentally I'll go back to the contract stage again. And I think the starting point is, getting the seat of the arbitration right. Now, the seat of the arbitration means that, the High Court, which will have jurisdiction, will accordingly be decided. Now, some courts, all of us know, are a lot more pro arbitration, pro commercial, and wants to dispose of these matters on a priority basis without keeping it. I may not be able to say the same with respect to the same speed with respect to all the courts across the country. So I think that's one place where parties can obviously start with, which is that having that clarity on the seat and therefore the jurisdictional court, which will be there in terms of deciding the Section 11 applications as one point. The second bit is obviously the fact that wherever possible, you have the ability to have a 3-member tribunal. Now, the minute you have the ability to have a 3-member tribunal, whichever party, I'm not saying that, be it the government entity or the private party, whoever is invoking the arbitration, comes with the comfort in the process that it is a neutral panel of 3 members who is there. So you start with appointing your nominee. There's another person who will get appointed from the counterparty side, and then there's a presiding who is going to get appointed. So I think as against agreeing on a sole arbitrator name vis-a-vis following a 3-member panel, I think there is some advantage in following a 3-member panel, and both of these are at a way before the dispute stage, at the time of entering into contract, few aspects that the parties can keep in mind. That is one thing. Next is obviously, I think in terms of choice of arbitrators, how do we, in the sense that a party who is initiating the arbitration, how is that entity making their choice of arbitrator? Now, sometimes there is an administrative delay and things like that, or just a decision not to agree to a particular name or not cooperate with the process. That's a strategic call that a party may take. But otherwise, very often the appointment process gets delayed because of the lack of faith in a name that one particular party has suggested. I have suggested Mr. X's name. The counterparty is not very happy with Mr. X for whatever reason. Now, being very careful about making your choice of who you would want to nominate can also, I think, go a long way in smoothing out the process for appointment of arbitrators. So I think those would be a few tricks of the trade.
Thank you, Tine, for that. We have about 15 minutes left, so being cognizant of the time, in case there are questions, please send them in. We'll try and weave them into the discussion. And I know that we had a lot to discuss, but some of the things will now obviously have to be dropped from the agenda. But one of the issues in the arbitration process itself is the entire issue of evidence, and we are still in that sense stuck in the traditional notions of leading evidence and cross-examination. Although there has been a certain degree of sophistication both from the PSU side as well as from on the private side in terms of getting delay analysis experts and your hot tubbing and all of that. So all of these things are still evolving in India. But Tine, just to start off with you, if you could just quickly tell us what can be done to simplify this process, and in your experience, whether summary proceedings or proceeding in a summary manner without getting into the cross-examination and examination in chief, if you think that is something that can work well in this paradigm.
So I think speeding up the process is something which ties in with a very basic objective of arbitration or alternate dispute resolution process. The starting point is obviously the law itself says that you don't need to follow strict rules of procedure. So there is a lot of autonomy which is given to the arbitral tribunal. I think there are two issues which sort of arise here, and which I think contributes to the delay and the point that Vishrov mentioned about summary proceedings and not recording of evidence, all of it. One is that given that it's a private proceeding and it is largely driven by consent of parties, the choice not to have unnecessary witnesses, choice to do away with a lot of procedural requirements depends on two aspects. One, the comfort of the arbitral tribunal in following a summary process, the comfort of the arbitral tribunal in experimenting. I mean, very often we don't see that, say, let's take the question of, experts who are doing a damages calculation. It is possible that you could do that through a hot tubbing where both the experts are put together, the issues can be trashed out. It may not always be the case that the tribunal or the parties are comfortable with following that process. Similarly, a lot of disputes can be decided purely based on the documents, and you can avoid going into oral evidence or affidavits of evidence in these proceedings. There again, the comfort of the arbitral tribunal and comfort of the parties. So I think it's a gradual process where you need to build in that level of sophistication into the process, which I think comes from all of us in this group who act as counsel, who act as arbitrators, and who are also representatives of parties. I think that comfort that we built in taking that call that I am happy following a summary procedure. I don't want to insist on everything. Sometimes what bothers council or bothers parties is that if I don't follow this, am I giving up one ground for me to challenge the award at a later point in time? So I think those concerns obviously comes in the way of the decision making to begin with. So I think that sophistication that can go into the running of the arbitration, which is a responsibility on everyone, the bench, the bar, and the parties, will definitely take a long way ahead in terms of dealing with these timeline issues. And I think it's a gradual process. It's not something that can happen overnight. We are definitely seeing changes from what it was 15 years ago, but still there's a long way to go.
Thank you for that, Tine. Mr. Mishra, just your very quick thoughts on how acceptable is this no cross-examination format in your experience with PSUs, and whether it is something that should be insisted upon.
Once more.
So if we were to,
there was some disconnection.
Sorry. So I'm saying that in your experience, doing away with this elaborate process of cross-examination and examination in chief, given that a lot of the disputes can be decided purely on the basis of documents, how receptive have you seen? How receptive is the PSU to an idea or a suggestion like this, and what can be done better in that context?
See, Vishrov, it depends on matter to matter. If the matter requires that somebody is blatantly saying that it is not possible, then it's okay. And authorities that don't have any problem also in the arbitration matters. But if it is not required, usually what is there, the parties who are going for the arbitration, they are also working in the same field. It is not that something different, but this cross-examination and the process of acceptance, denial, all that, they are the things which are to be followed because there is some process. So it has to be followed, and it all depends on case-to-case basis. Coming back to the dispute resolution process, for example, in CCI or other mediation process, NHI is now surprisingly all the awards, like the majority of awards that have been won, they have again gone to the CCI in order to get it settled. The award 34, 37 from the High Court, Supreme Court, everywhere, and again it has been settled in the CCI in order to just give a close to the matter. Then enough, let us decide it on merits or whatever it is. So I'm not very much in disfavor of this cross-examination and other litigation process. The thing is that whatever, it should be settled by independent people, and the concession committee or the for example, I will tell you one special example. In one of the party is state government, then the matter will come. Madhya Pradesh Madhyastham Adhikaran Adhiniyam 1983. Till date, nobody has got even one claim from them. Got some dues which were due there. No claim, nothing known as claims. In cases they have given EOT. Otherwise, it is a dead end. You just paper and forget it. So in those cases, and you don't have any other way out also. In recent past, there was some judgment that if you have an agreement, in the agreement you have 1996 arbitration, then because the state government was knowing that this was there, even then if they are saying that 1996 arbitration there, we should go on. Again, the Supreme Court has told nothing doing. State government is having their thing, go and do that. And this problem exists in 4 or 5 states.
Correct.
Gujarat, Madhya Pradesh, Chhattisgarh, and Bihar, or if some other states have also built. Then I think otherwise there is no way out. Which you have received is so much of litigation, paying so huge amounts of fees to the arbitrators, and even then you are going to settle the things in the CCI itself. So I think that much more has to be done in the dispute resolution process, because there is a saying in Hindi कि जिस देश में न्याय न हो वहां काम ही नहीं करना चाहिए, लेकिन यहाँ जाएंगे तो जाएंगे कहाँ? एक ही जगह है. There is one single place and you will have to fight within itself. Let us see.
Thank you.
Some things will come up.
Thank you for that. So we are in the last 5 minutes. So the most important part of any dispute is enforcement and execution. So just a couple of minutes from Kunal and Mr. Ramana on their experiences, especially with the entire deposit requirements and whether it is working well or not. And then we'll close out with the final comment from Tine. So Kunal, just over to you. Your experience. I mean, power sector, everyone knows the lack of enforcement challenges, but your experience and what can be done to change it.
Yeah, no, so that is true. You have seen the Andhra Discoms example where there is already an High Court order, which is where a lot of the dues are pending from Andhra Discoms. Then there is sort of Punjab's example where agreed PPA was changed by or at least was tried to be changed by a bill. So there are a lot of such issues. In fact, the execution is not that easy. If you just talk about power sector, if there is an order by a state commission, then state commission does not have execution powers also. They have a power under section 142 of the Electricity Act, but that can only sort of give a penalty on the officer in charge or sort of some sort of a criminal action against them. But there is no provision even to execute its own order. So APTEL has a power to execute, but the commissions does not have. So there are challenges at the for execution of any of these. At least if I say litigation matters, and all arbitration matters also, they end up sort of going into appeal in sort of challenge under 34, 36. So it is not an easy task. It always takes time, and sort of you have to fight it up till the end to sort of get your money.
Thank you. And Mr. Ramana, over to you. I know that this is a favorite topic for you. So your views on this.
I think 2015 amendment has been really a good amendment. That automatic stay concept has gone away, and at least at pro arbitration courts, we are able to get very good relief. There are instances where we got 100% deposit order, and also the release of the money on furnishing the bank guarantee. But this again happens only in the very good jurisdictions, and some jurisdictions we had difficulty in getting that 50% also. I think another important relief from the public sector perspective is the Niti Aayog office memorandum that came in 2016. I think that has actually helped us in getting relief. 75% of the award amount is released against bank guarantee. And there was also an amendment to that. Earlier, the first initial Niti Aayog memorandum talked about furnishing interest also, but that was waived off subsequently. And with these two reliefs, we were able to enforce award reasonably well. And again, let's see how the 2021 amendment will take back this enforcement, which we had quite a successful run of enforcement we had for the last 5-6 years.
Thank you. Tine,
I will do like a 40-second final word on it. I think one is definitely the enforcement climate in the country has significantly improved. Domestic awards, foreign awards, whatever it is, it's significantly improved. Courts are really pro enforcement, and to a large extent, they all respect the idea of giving a security if you have to get a stay. And otherwise, also courts are comfortable proceeding with enforcement in parallel to a pending Section 34 challenge proceeding, which is there. So I think definitely we've seen a positive change in the last 5-7 years, and the hope is that that will continue and gives parties the much needed relief that they've gotten in the arbitration to actually transpire into what they were looking for in terms of money. Yeah. So I think, it's definitely been a good few years in terms of enforcement.
Thank you for that. And since Abhijit is now on screen, it's time for me to go off. But I would like to thank all the panelists and everyone who's in attendance for listening to us patiently. Thank you very much for taking time out. A big thanks to Neeti, MCIA, Abhijit, and the team for having us, and a special shout out to Bakul and Veer, who are part of the Trilegal team, for getting all of this together and making sure that that this happens. So thank you, everyone, and it was a great experience, and we hope to see you back again next year. Thank you.
Thank you.
Thank you,
so much.
everyone.
Thank you, Vishrov.
Thank you.
Thank you.
Thank you.